Welcome back, everybody. We are doing evidence marathon, and we will try to do the whole Bayer Act, not like from the only prelims point of view. So we are doing evidence marathon. We'll try to do in very minimum parts and not carrying to the various sessions. We'll just keep a very few sessions. So let's just start in an Evidence Act 1872. How many parts are there? So these are the preliminary things that we should remember. How many parts, how many chapters are there, when it was assented, when it was enforced, and James Stephen you should know, and the other preliminary things we will be starting with. So we will start with the preamble. Part 1. Part 1 states about the relevancy of facts. Very important. Like whole evidence act is important. Each and every part, each and every section is important. Chapter 1 preliminary. We have short title, extent, commencement. 2 is repeal. 3 interpretation clause is very important. 4 contains presumptions. So whenever anything comes on the presumptions, your section number 4 should be automatically clicked in. The section 4 may presume, shall presume, and conclusive proof. And 3 talks about the various definitions. Then we have chapter 2 of relevancy of facts. Chapter 1 is preliminary. Alright. Chapter 2 starts with 5 to 55, I think. So this is relevancy of facts. In the first 5 to 16 sections are very generic, are general, alright. Which means section 5 states evidence may be given of facts. So section 5 says of which evidences you can give. आप साक्ष्य किस किस चीज़ों का दे सकते हो. आप evidence का issue fact and issue और relevant fact दोनों का दे सकते हो. We'll see the difference between both of them. 6 says forming the part of same transaction, res geste. Then 7 is facts. This is important. 7, how the 7 comes. Occasion, cause, effect of issue. Effect of facts in issue. So occasion, cause and effect we see in 7. 8 talks about motive, preparation, previous or subsequent conduct. This has been asked, but kind of conduct is section 8 talks about. The section all talks about previous and subsequent, motive and preparation. Section 9, facts necessary to explain or introduce relevant fact, and TIP is a part of section 9. So section 9 talks about facts which are necessary to explain or introduce relevant facts. Alright. Now 10 is things said or done by conspirator in reference to common design. So you just keep a different columns for different sections because they are going to be interlinked. So common conspirators 10. We have some only few sections which directly explicitly says that these are related to the criminal conspirators. So these are conspirators, not criminal conspirators. Things are done by conspirators in reference to common design. When facts not otherwise relevant become relevant. This is important. When facts which are not otherwise relevant but becomes relevant. Plea of alibi comes here. 12 suits for damages, facts standing to enable court to determine the amount are relevant. So under 12, the damages are being counted. And 13, which right or custom. When right or custom is in question, the 13 kicks in. Each and every section of Evidence Act should be on your tips. 14 speaks about the existence of state of mind, body or bodily feeling. Alright. 15 talks about whether act was accidental or intentional. All these are going to be accidental or incidental. क्या पैक करेगा?
गोलगप्पे खाने जा रहा हूँ, तेरे लिए पैक करा के ले आऊँगा.
16 existence of course of business when relevant. So all these three are going to be very important. So 14 talks about state of mind, body or bodily feeling. 15 talks about accidental or incidental facts bearing on question, and 16 talks about course of business, existence of course of business when relevant. Then from 17 to 31 direct, we will have various other sections as well which will have the direct testimony to the admissions, but some are 17 to 31 sections. They are directly under the heading of admissions, We also have another sections which directly hit admissions, but currently these are the explicit ones. So admissions, where admission is defined under 17, admission is being defined. 18, admission. Now who can admit? By party to the proceeding or his agent, suitor or party interested in subject matter or whom interest is derived. 19, admission by person whose position must be proved as against party to the suit. These all are important, and basically their illustrations are important. Questions are asked from the illustrations only. 20, admissions by person expressly referred to by party to the suit. That comes under 20. 21, against persons making them by or on their behalf. Proof of admissions against person making them. 22, oral admissions as to the contents of documents are relevant. Read the title very carefully. 22, oral admissions as to the contents of documents are relevant. Mark it down here. We will have to explain it very deeply. When oral admissions as to the contents of electronic records are relevant. Admissions in civil cases. 23 talks about admission in civil cases when relevant. 24 talks confession caused by inducement, threat or promise when irrelevant in criminal proceedings. Therefore, the title of 24 is when ITP, inducement, threat or promise are irrelevant in criminal proceedings. We are not talking about irrelevancy 24. Then 25, confession to police officer not to be proved. Direct title based questions are asked in your judiciary exams. So title number section number 25 has that when the confession is given to police officer, that need not to be proved. Confession by accused while in custody of police not to be proved against him. 25, police officer. 26, police custody. Alright, how much information received from accused may be from circumstantial evidence. 27 is circumstantial evidence. Accused, how much information? Discovery statement, you can say, comes under 27. Alright, 28, confession made after removal of caused by inducement, threat or was relevant. Direct bearing. 24, 28. 24 say that if ITP is there, then confession would be relevant. When 28 says when ITP removal has been done, then that is relevant. Now 29 is secrecy or promise. So confession otherwise relevant not to become irrelevant if the promise or secrecy is given. 30, consideration of proved confession affecting person making it and otherwise jointly under trial for the same offence. Now we have done 10, just add a 30 to it. 30 to it as well. What did 30 says? 30 says consideration of proved confession affecting persons making it and others jointly under trial for the same offence. So this is joint confession. We cannot say joint confession. We'll have to see. There's a proper term for it. 31, admissions not conclusive proof but may stop. It's a major thing and very important. The 31 states that admission is not conclusive proof but may act as a stopper. Now a second heading, that is statements by person who cannot be called as witnesses. Very important. Alright. 32 in itself is very important, and you should make a case law list here only because there are various cases under the 32. Cases in which statement of relevant fact by person who is dead, who is either dead or cannot be found, etc. is relevant. Now, under what conditions you are making the statement of dead person and a person cannot be found relevant? When it relates to the cause of death. Alright, that is dying declaration. When it is in the course of business. When it is against the interest of the maker. Where it gives opinion as to the public right or custom matters to general interest. Or relates to the existence of relationship. Made in a will or deed relating to the family affairs. These all are asked in your preliminary exam. Your every word is important. In a document relating to transaction mentioned in clause 13a. Clause 13 we have right and custom. This thing. It is made by several persons expression feelings relevant to matter in question. We will discuss in detail. Alright, 33, relevance of certain evidence for proving in subsequent proceeding the truth of facts therein stated. That is to be read with 32 only. Next heading is statements made under special circumstances. And now what is special about them? Entries in books of account when relevant. So not every time it is relevant, but when relevant. Relevancy of entry in public record, that was entry in books, 34 books. 35 public records made in performance of duty. 36 statement in maps, charts and plans. Just like look for the word relevancy, 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 relevancy. In chapter 2, we are just making sure whether a particular fact is relevant or not. We are not testing the admissibility, but we are testing the relevancy. So 36 talks about relevancy of statements made in map, charts and plans. 37 talks about the relevancy of statements in acts or notification, public nature. 38 talks about anything contained in law books. Will have the same provision in the admissibility chapter. Then you will say, ma'am, we have done this, then again it is repeated. No, it is not repeated. The word here, it is relevancy and there would be admissibility. A relevancy of statement as to they contain in law books, 38, and maps and charts, 36. All these things are tricky, and when answering MCQs you tend to forget them, so just revise them again and again. Now the question is, how much of a statement is to be proved? Are we required to prove the entire statement? What evidence is to be given when statement forms part of conversation, document, electronic record, series or letter or papers? We'll see. Then judgment of courts of justice when relevant. This is important. Judgments of courts of justice when relevant. Their previous judgment relevant to bar a second suit or trial, that is res judicata. So section 40 says that if there is previous judgment relevant, that would be relevant to bar second suit or trial. Relevancy of certain judgments in probate etc. jurisdiction, this also been asked under 41. Then relevancy in effective judgment other than those mentioned under 41, their relevancy. Judgments etc. other than mentioned under 40, 41, 42. When element 44, fraud or collusion in obtaining judgment, incompetency of court may be proved. Now it says what may be proved under 44? Fraud, collusion in obtaining judgment or incompetency of court. On these factors, the new evidence may be proved. Fraud, collusion, incompetency. Now, opinion of third persons when relevant again holds very dear when appreciating the judgment, when appreciating the facts. 44 to 45 talks about opinion of experts. You very well know that. 45A, opinion of examiner. Just the opinion of examiner of electronic evidence. 46, facts bearing upon opinions of experts. So 45 tells you about opinion of experts, and 46 tells you about facts which bear opinion of experts. 47, as to the handwriting when relevant. We asked so many times. 47 relates to the handwriting, under which circumstances who could give evidence of handwriting. Opinion. Now just observe that all these starts from the opinion. Alright. 47A is digital signature. 48, opinion as to the right or custom when relevant. So you can make a separate chart for which right and customs are there. So we have 13, we have some part of 32, and we have 48. Alright. 48 is opinion as the existence of right or custom when relevant. 49 as to the usage, tenants etc. when relevant. So you can also add 49 to it. 49, usage, tenants when relevant. Opinions on relationship when relevant. You can also make a chart, relationship, where 32 is also there, and 50. Opinion on relationship when relevant, and grounds of opinion when relevant. 51, on what grounds the expert has given, and that also is relevant. We are talking about the relevancy only. And character when relevant. Now character when relevant, in civil cases character to prove conduct imputed irrelevant. So in civil cases character prove irrelevant. States 52. 53, in criminal cases previous good character relevant. These all are important sections. 53 states that in criminal cases a bad character, previous good character is relevant. 53A, evidence of character or previous sexual experience not irrelevant in uncertain cases. With all the amendments we have to very much look through that. Alright, evidence of character or previous sexual experience not relevant in certain cases. In certain cases. 54, previous bad character not relevant except in reply. 53 read with 54. Alright. 53 say that previous good character are relevant. And now 54 say that previous bad character not relevant except and reply. And 55 character affecting damages. So 52 read with 55. 55 civil cases we are not making the character relevant, but under 55 we may make it relevant for determining the damages. Then part 2 and part 3 we evidence act is divided into 3 parts. So part 2 is on proof. Part 1 was on the relevancy part. Now we have on proof. Chapter 3, facts which need not to be proved. So the Evidence Act is very beautifully drafted and tell you everything. You just need to understand it. I guess I should complete it in the next session. So in the next video, you will be having both the parts from the Bail Act Index, and then we'll start with the main content with the case laws and with the MCQs. Thank you so much.